for watching.
Well, hello and welcome to News Center. I'm Ashmit Kumar. Abraham Lincoln became the US president in 1861. Just 1 year before that is when British India had enacted the Indian Penal Code, that's way back in 1860. It is this criminal justice system that is sought to be phased out. The government has tabled the Bharatiya Nyaya Sanhita Bill in Rajya Sabha to be the next logical successor to the Indian Penal Code, or the IPC. Now, it is much smaller. It has 356 clauses as opposed to 511 sections of the IPC. And as per the statement of objects and reasons, the bill aims to do four things: to strengthen law and order, to simplify legal procedures, to make existing laws contemporary, and to create a citizen-centric legal structure. Expectedly, there is excitement and concerns about the changes. Let's take a look at some of the key changes. Number one, sedition has been cast out of the BNS. The application of this IPC was, in fact, a provision was heavily criticized and even challenged in courts. But while it is missing the BNS, there are those that ask if it's really gone. Clause 150 of the BNS reads that whoever encourages feelings of separatist activities or endangers sovereignty or unity or integrity of India shall be liable for a maximum punishment of a life term. Some caution that the open-ended wording of this clause allows scope for misuse, like the sedition provision under the IPC. Number 2. For the very first time, the BNS bills defines what is terrorism and terrorist actions. It was missing in the IPC. But here too, the language used has inspired some concern. The bill says that whoever commits an act in India or abroad with the intention to threaten the unity, integrity and security of India, to intimidate the general public or a segment thereof, or to disturb public order would be liable to face action. Some experts warn that the last bit about disturbing public order may be prone to abuse. Number 3. Another concern has been the clause 195. Now, it deals with hate speech and has been carried forward from section 153B of the IPC. But here's one key addition that has been made under clause 195. Under this new provision, anyone who makes or publishes false or misleading information jeopardizing the sovereignty, unity and integrity or security of India shall be liable to face punishment for maximum punishment of 3 years. Number 4. For the very first time, mob lynching has been defined. It was missing under the IPC. It has now been introduced as clause 101 or 101. It clearly provides that any group of 5 persons or more acting in concert commit murder on the grounds of race, caste or community, sex, place of birth, language shall be liable to face a maximum term of life imprisonment. And finally, number 5, clause 69 is an interesting addition. Here, the BNS provides that whoever, by deceitful means or making by promise to marry a woman without any intention of fulfilling the same, has sexual intercourse with her, shall face the maximum term of 10 years. Importantly, deceitful means has been defined to include false promise of employment or promotion, inducement, or marrying after suppressing identity. And number 6, BNS has also introduced the concept of community service for smaller offences such as defamation, attempt to suicide and non-appearance after proclamation. The bill now has been referred to a joint parliamentary committee. The government is hoping that it can get the bill passed in the winter session of the parliament. To take this discussion forward, I'm now joined by senior advocate Arvind and ace criminal lawyer as well as public leader Majeed Memon. Gentlemen, thank you so much for joining us. Mr. Datar, let me come to you. The IPC, we've had it since the year 1860. So it's been 160 years that we've seen the criminal justice legal framework evolve. It has managed to keep up with very many changes that we've seen over the last several decades. Was there a need felt within the legal community that there is an urgent need of an overhaul?
I don't think there was a need for replacing the Act, the IPC completely. The IPC is now there for almost 160 years. And those of lawyers who practice on the criminal side have not seen any major concern with the IPC. Secondly, we have been completely used to various provisions. Everybody knows what is 302 IPC, what's 420, what are the other sections. So there was no need for a complete overhaul. You could have added these sections like terrorism, and the section you just mentioned could have been added at the appropriate places without altering the entire provision completely. Secondly, what was surprising to me was that such a major change should have been preceded by some discussion paper. For example, when you had the data protection bill, you had the Sri Krishna committee who gave a draft white paper, then you had a draft bill, then that was subject to public discussion, only then introduced in Parliament, again subject to 74 changes. So in a matter of criminal law with such major changes, we still don't know what was the expert committee, what are the recommendations, why was the need for this complete 180 change. Every law has been replaced. And this complete, and if you see the Evidence Act, virtually the same sections are with just new numbers. Now 302 is 150. Now every police officer knows what is 302. Now somebody has to relearn 150, relearn the again sections. It is going to be a very problematic thing. The intentions are good, but they could achieve the same objective with tweaking the law rather than replacing the law.
Let me take that across to Mr. Memon. Mr. Memon, thank you so much for joining us. The view that is emerging is that this overhaul perhaps may not have been the need of the hour, but rather just a few deletions or additions to the existing IPC, which has served good for the last 160 years, would have achieved the same objective. Do you agree with that?
No, before I answer your question, I must introduce the basic facts in the sense that what is the importance of criminal jurisprudence or criminal justice system in a civilized country governed by rule of law. Please remember that a country's civilization can be best assessed by the success of its criminal justice system. If your criminal justice system is weak or is not effective, you are
Sure.
not civilized country. And in order to uh, uh, have assessment of success of criminal justice system, one has to turn to the prisons of the country. Remember, this is very important. And if by that yardstick, if you look at India's prisons, you see, I fortunately had the opportunity of working for almost 5 years as a member of the Parliamentary Standing Committee for Law and
Sure.
Justice. And I have given lot many suggestions with regard to various weaknesses in our system. Firstly, I must tell you that our prisons are overflowing with inmates, which is a bad sign. And in that context, if a whole world, examination you take as far as the criminal justice is concerned, you will find that Netherlands probably stands at the top, where the number of prisoners at a given time is minimal. In the whole country, there are
Sure.
only 19 prisoners, whereas in our country, every prison is overflowing, and there is a need for construction of more prisons, which is only indicative of miserable failure of our criminal justice system. Now, what is the remedy? The remedy, you see, you must understand that for the past 76 years, under the current constitution from 1950 onwards,
Sure.
British laws have been adopted, and we are governing our system under these existing criminal three laws, as the government says now. The Honorable Home Minister wants a total revamp of CRPC, IPC, and Indian Evidence Act. It is not a small job; it's a marathon assignment. You can't, in one stroke, you see, bring three new laws and substitute them for the laws that have been were used for the past over a century. Now, remember, the government, there are a few, I'm happy that
Sure.
the government has at least thought about need for a reform in criminal justice system. Because if the constitutional commitment you see, you will find that we are bound, the
Sure.
state is bound to provide uh, inexpensive and speedy justice to every citizen. Now, by this test also we have failed. Where
Mr.
do you
Memon,
have speedy justice?
if I may come in on a supplementary question,
Yes.
just to build on the point that Mr. Datar had made, you're saying that perhaps there was a need of a remedy, but maybe such a shock and awe response was not required. Perhaps a more gradual consultative approach was required. Is that your view, that perhaps more public consultations, perhaps more committees to dwell on such changes? Is that the answer?
No, certainly, precisely. That is why I have said a minute earlier that it is not a small job, that you've just thought of it, and if you have numbers, you will get the bill passed through the voice vote or something like that. That would be disastrous. You see, if you are touching this subject, you will have to have very careful examination of each and every provision of each of these three acts. It's not sundry that you can lock, stock, and barrel
Sure.
replace something like that. As my friend has rightly said, and I would endorse that, that we need marathon exercise of study from the experts. You see, the bar is to be consulted, the bench must be taken into confidence, the law commission must be there, the people's
Sure.
opinion is to be sought. It is not a small job. And then you can't do, you see, in one stroke, that you will say a whole criminal procedure code to be replaced by, and you
Sure.
give a Hindi name as though it will change the entire system. It is not at all. I'm sorry. I am agreeing
Well,
with
we're
the
seeing a very
Honorable
different debate.
Home Minister. I am seeing,
Well, the name
it's very
itself has
fine.
inspired some degree of debate. That name itself has inspired some degree of debate. We'll save that for another day. But Mr. Datar, if I may get you in on this conversation, the expectation is that once the bill is passed, it'll be rolled out in a period of 36 months, 3 years. Is that will it be that simple, a rollout in terms of 3 years, or do you expect teething worries at a time when you're subjecting the entire criminal justice system to an overhaul courtesy these three acts?
Well, from the newspaper reports, I find that the bills have been referred to a parliamentary committee. Perhaps Mr. Memon can confirm that. If it has been referred to a parliamentary committee, then I think they must invite comments from various uh, bar association stakeholders who have given evidence. Like when they tried to reform the direct taxes, people like me gave evidence before the parliamentary committee. But I think before that, we'd like to know what was the expert committee report. And as Mr. Memon pointed out, we should first identify what were the problem areas, what was the need for this entire amendment. Well, now it has been done. Now the bill has been introduced. We have to move on with that. So I think the parliamentary committee which is going into it must really get into details. For example, the direct taxes code bill was first preceded by a paper, then it was a bill, but the bill was not passed. I mean, better sense prevailed and they allowed the old Income Tax Act to continue. Similarly, in the PDP bill, there were 74 changes and then now the bill has come. So I would personally prefer that let the parliamentary committee decide, and I really hope that they drop this idea of having these three new laws. There's no need. They can just amend the laws because the cost of implementing is going to be huge. Just imagine everybody has to relearn the law. The judges have to again reinterpret the provisions. And if, I mean, I really don't know because I find Evidence Act is the same. In IPC, 80% of the provisions are same. So what are you trying to achieve by changing the law? If you want to, like Mr. Memon said, the major problem is the under trials. The major problem of the criminal justice system is to have, they are now, as per the National Crime Bureau report, they have 4,27,000 under trials in India. You know, and this entire thing of the Home Minister saying we'll finish the trial in 3 years, I don't think it's possible. You see, you had these declarations in the Consumer Protection Act that a case will be over in 1 year. It's not possible. I mean, do you have the resources to make a case over in 3 years? What about appeals pending in some court for 10, 12 years? How are you going to get rid of it? It's not some magic wand that you have a new law and you dispose it. One other major problem in not only in this government but previous government is if something is going smoothly or you want to have a reform, the reform is by making a new law. I think the reform should come by the implementation of the law. Try to see where the law, how it is being implemented, like Mr. Memon says about the criminal justice system, about the trials, about the prisoners. That should be the focus area than replacing the law.
Sure. Mr. Memon, let's get into the specifics now. There are concerns that have been raised, whether that's Section 101 that defines terrorism or whether that's Section 150 that seeks to replace the sedition provision. The concerns that have been raised is that in all of these provisions, the wording regarding public order, national security, sovereignty has been used in a way that it will lend itself to potential misuse or potential abuse on the ground, like we saw with the sedition provisions, or like it was commented that perhaps in some cases the UAPA is being overused. So just your thoughts on that in terms of the wording and whether this national security bogey, which has been red flagged by the Apex Court as well, is prone to misuse.
Now, Ashmit, I must tell your viewers that as Mr. Datar has rightly said, and I fully endorse his view, that it is a gigantic job. You will have to change the syllabus of the law course. You will have to teach students something new that you are bringing in, which is not going to be possible even in 3 years or 5 years. It might take 15 to 20 years to change the whole outlook of the criminal justice system. And there is no need to take such a marathon burden on yourself. What is important is now, for example, there are a few suggestions that are shown that the government proposes to do. For example, remember one thing, that the laws need to be always flexible. The Constitution, which is the apex law, you see, apart from these three acts, three laws, the Constitution has to be neither too rigid nor too flexible in order to serve the need of the people governed under it. Now, even laws, every laws have to be changing with the change in society. The needs of the society keep on changing as society changes from time to time. And therefore, there's always a need to have a relook at laws, but not in lock, stock and barrel, as the Home Minister or the present government suggests. Now, for example, there are a few things which we will seriously oppose, or even any activist or the bar or the bench, everybody would oppose. For example, this particular change suggests that the arrestee, after arrest, police custody, which today under the Code of Criminal Procedure Code is 15 days. Beyond that, you can't be kept in police custody. Now they want to enhance it to 60 days or 90. This is horrible. This is going to only add to the turmoil of the people. Now, about